Do you want to watch something? No? Let me know when it's done. And, I can't, I can't. Yeah? Oh, the car's going off. They're lowering down the coffin. Mama, what's the deal? Okay. Sandwiches with brats. Hi. Oh, goodness. You want to watch something? Yeah. Oh, this is. We gotta do it on Bonnie's account, you know? Bonnie. Let's see lights off. Oh, yeah. Two of them, right? Yeah, two of them. He's got two today. See, what gives? Flint the. Flint. What gives Flint the right to auction off cars doing donuts?
Welcome once again to Leto's Law. Here's Steve Leto.
I did the video recently about the cars that were impounded in Flint because the allegation is the drivers were doing donuts in a private parking lot. And the people who owned the parking lot actually called the police and said these people damaged our parking lot. And the allegation is that there's quite a bit of damage done to the parking lot by those people. And I didn't get into that in the video, but I talked about how the police identified the vehicles, impounded the cars, but announced they're going to auction the cars off as a result. And I was basing my story on a piece I saw, and in that piece, the writer had said that the fact that these cars are on private property might impact the legality of seizing the cars. And I pointed out that actually there's a lot of laws that address things happening on private property, which don't need the owners pressing charges to make them stick. The best examples I gave were reckless driving or drunk driving. And reckless driving, of course, does play into what happened in this case. The allegation is that these vehicles are being operated recklessly, but the driver is doing donuts on private property and causing damage to the private property. Now, in case you're curious, if you read the news reports, the owner of the property did complain. However, I had a lot of people ask me and say, Steve, just on a hypothetical intellectual exercise level, what right do they have to seize the cars and auction them off and keep the money? Wouldn't that be an excessive fine? Especially if reckless driving is the underlying charge, because reckless driving says there can be a fine up to a certain amount of money and so many days in jail, and these cars are worth more than that certain amount of money. Well, a couple of points I need to make, and one of them is this happened in Flint, Michigan. That is important because, and I did a video about this a few years ago, but I realize now that I always forget. I often think that I'm having a conversation with you. Not you, you. I'm having a conversation with you. And the conversation that you and I are having is all the videos I'm making over the years and all the comments I get back and the videos I continue to make. It's a conversation between us. And I often forget that not everyone has seen every video I've ever made. And likewise, some people probably haven't been watching me all that long in the sense that I think the video was probably 4 or 5 years ago. But there was a time when the city of Flint started cracking down on street racing, drag racing, stunting, showboating, whatever you want to call it, where people were doing donuts and drifting and racing, and they declared it like a public nuisance. And that's the important thing here, because the allegation is that the people who were driving the vehicles, their cars were seized. I believe they've been charged with reckless driving, and they've been charged under a Flint City ordinance that goes along with reckless driving. And this is important because under the reckless driving statute by itself, the vehicles would not be subject to forfeiture. They wouldn't be, because the statute says you fine and possible jail time, right? So I went and dug it up. It took some effort because it's a Flint City ordinance as opposed to just a Michigan state law and the blue books behind me. But you should be aware that there are laws at several different levels wherever you might be in America. So there are federal laws, there are state laws, there are often county ordinances, and there often are municipal ordinances for the city, the village, the township, wherever else is that you're more specifically designated as your place of living. So
now,
if
when
you
they
lived in
call
Flint,
me,
you'd be subject to the laws of Flint, the
either
laws
I'll
of
walk
Genesee
there
County,
and get
the
my
laws of
car
the state of Michigan, and the laws of the United States of America.
with you.
And
get
what we're
our
talking about here
exercises
is
and
the
get your
ordinance
pop.
number.
Let me
It
just
comes from
watch
chapter
out.
30, not chapter 28.
No,
And
you're
remember,
doing
Steve,
it for
chapter 28
your
is where
own
the
health.
motor
You don't
vehicle
need to
stuff
know
is.
how many
Yes, it is.
steps
Chapter
you
30
have.
is where the nuisance
But I'm
is.
wearing my watch, so I know how
Chapter
many,
30
so I
of
can
the
say I
Flint
did
Municipal
more
Code.
steps than you.
Nuisances. And they
I did
added a
1,000.
section under nuisances entitled
Yeah.
reckless
1,000
driving.
million.
So it is hereby ordained
You're not
by the
supposed to
people
say-
of the city
yeah.
of Flint.
You're supposed to
Ordained
say, oh my gosh.
an ordinance to amend the Flint City Code of Ordinances by amending Chapter 30, nuisances, by adding Section 30-40, reckless driving, which reads, A, any motor vehicle used to engage in reckless driving in the city of Flint is hereby declared a nuisance. All such nuisances are subject to enjoyment and abatement as provided under state and local law. Any person or his agent or employee who owns, leases, or operates a motor vehicle in violation of this section is guilty of a nuisance. And you read the section itself on nuisances. It says it is a nuisance within the city limits. The city's got the right to come in and abate the nuisance. So you've got a house that fell down in a windstorm and has just been sitting there and you kind of abandoned it, and now it's like attracting all kinds of bad attention. The city might come by one day with a bulldozer and clear that lot and charge you for it. They're going to abate the nuisance. So the city attorney, and this is section B, city attorney may maintain an action for nuisance abatement,
That's a lot of
applicable
tools.
relief in the name of the city of Flint,
Yeah,
and
pressure.
Genesee County Circuit Court, and may
Yeah,
settle
pressure
any
there.
such
You know, like
action
women,
for,
they use that
at
air
minimum,
pressure.
the payment of
Propane,
an administrative
air
fine
pressure.
of no less than $900
You know, they have to
and
say too.
all accrued towing and storage charges. So they can do
Was that
that.
where he was pushing it into
That's
the
set forth in
engine
this
and
section.
getting
Reckless
out the
driving means
tailpipe?
conduct
Yeah,
violates
this
MCL
thing,
257-626, which is the statute I read to you yesterday. And it says, or otherwise operating a vehicle with willful or wanton disregard for the safety of persons or property, so the damage to the property is
Everything.
qualified as reckless driving. including but not
Have you
limited
seen-
to the use of stunt
Hey, bud.
driving techniques
Have you
such as
seen-
figure eights, sliding, drifting, and donuts. And interestingly, I
Wanna
looked
watch
at
this
the
shit?
definition of
Oh,
donuts.
it's extremely
So
goofy
they
movie.
apparently assume that everyone knows what a donut is.
Huh?
Now,
No.
When we get back from the walk.
my
Can I have my
audience
shoes on?
knows what donuts are.
Yeah,
In
you're
the
gonna need
automotive
shoes.
sense.
Yes, I'll get you
But
a
the
drink and
interesting
drop
thing
you
here
off.
is that reckless
Instead of
driving,
going
this
to
section under the nuisances section,
Oh,
simply
in
says
Myers.
that the city attorney can maintain an action, and in essence, if the vehicles were seized
I'm not doing
because
my
they're subject
slippers,
to
you know.
abatement,
The
then
smells could
the
shut us
city
off.
could actually say, well, you can have your car back, but you got to
Yep.
pay at least $900
No, I'm
plus
not
accrued
walking.
towing and storage charges.
Yep.
But I assure you that elsewhere in the nuisance section simply is the language that says
Hey, let me
that the
ask Mom.
city has
Hey, Mom? Will you drop us off at the car dealer?
I told him I'd rather walk. It's
Right to-
beautiful.
Told you.
abate a nuisance as they see
Don't
fit.
make me give you the
And
look.
abatement often means the seizure and destruction
You know
or
that one
seizure
you get
and
nervous
removal
at when I'm looking
of
at you?
the
Yeah.
offending
Don't look at me that way.
nuisance.
Yeah.
And so they're saying that these
So you look at
vehicles
me and you
in
won't
the
look at
hands of
me.
these
you
people
put-
have become
Mhm.
nuisances. Obviously, if you own that vehicle, did nothing wrong but drove it within the law, the car is not a nuisance. They're saying that the car in the hands of these people doing this damage have become a nuisance, and they've got the right to abate that nuisance. And so they seize the car, and they say at a minimum you can get it back by paying all that money. But they say we've got the right to abate the nuisance, which means that we have the right to take the vehicles out and dispose of them. Now, I know some people are going to say, "But Steve, I understand what you're saying. I still disagree with it." You are free to disagree with it. And this law, this ordinance was passed recently. And by recently, I mean summer of
Hasn't
2022.
been tested in the
So this
courts
is a
yet.
relatively recent law in the grand scheme of things. I don't know if anybody has challenged this on any constitutional grounds or other. Because obviously, if they take your vehicle out and they sell it and they make money off it, the vehicle had value, why wouldn't the money go to the owner of the vehicle? They're going to say, well, no, the vehicle actually was a nuisance. And we abated it in a very efficient way that created money for us. It'd be kind of like if that house that fell down earlier I described to you, if somebody scraped up that residue and took it to a dump, and the dump said, yeah, we'll give you $1,000 for it because there's useful stuff in there. Copper pipes, brick, I don't know, I'm making stuff up here. But my point is, who would get to keep that money? And some people are going to say, well, Steve, it seems to me we've talked before about excessive fines in the Constitution and the Bill of Rights. And a fine cannot be excessive. So if the person gets fined $500 for being a reckless driver and $900 for being a nuisance, then taking their car and selling it, the creation of that money, if they keep it instead of returning it to the owner of the car, that would seem a lot like an excessive fine. And I see that argument. I do. But the city has done this in a way that I think will get them a lot further than if they'd simply said, by the way, reckless driving in our city, you owe us your car. They're saying, no, we've declared this a nuisance and a matter of public
We'll go
health
inside
and safety.
McDonald's and eat.
And I can tell you
Go
that
inside McDonald's
these
and eat.
ordinances, because there's a couple of them,
I'm not eating anything. I got a
inspired
ton of food.
by
Yeah.
We
some
got the hot dog
massive
stand, I got
situations
potato
involving
salad
street
today.
racing
Yeah.
Or I can
and
make
shows
sandwiches
and,
and have
street
potato
takeovers
salad.
Yeah.
and those kinds of events.
Or I can make
And the city
bratwurst
council
and have.
felt they were
Bratwurst.
compelled to do something about it.
Along
So
with
this is what they've done. And like I said,
for
it's a
side dish.
Flint
You mean
city ordinance.
what?
But it's not an ordinance
I
within
can
the
have hot
driving
dogs with
section.
potato
It's an
salad.
ordinance
I can
within
have
the
sandwiches with
nuisance
potato salad.
section.
I can
And
have
they're saying this
bratwurst
kind
with
of
the
driving
green bean.
creates
No,
public
potato
nuisance.
salad.
And so if you look up the story, simply type in
I love
Flint
potato salad.
I love
auction
bratwurst. They're the
and,
worst.
donuts.
You know
You'll
why
find these
they
stores.
were-
There's a ton of them. And
had a problem with
Enlot,
them.
which is a
Hmm.
local
They
news
need to
source in
be
Michigan,
grilled.
Yeah.
has
They need
quite
to
a
be
bit of
sharp
coverage
burned.
on
Yeah.
They
this.
need to
And
be
dig through the
flame
stories
broiled.
because some of the stories
Yeah.
are short, some of them have more detail. But one story in particular has an interview with the owner of the lot where this took place. And he says that his lot was damaged because apparently it was recently resurfaced. And the resurfacing cost a lot of money. and somebody went in shortly after resurfacing, and he says, in doing their donuts out there, damaged the lot. And he puts a dollar value on it that's quite high. And so, believe it or not, in the big picture, high altitude overview of this thing, if the damage that he describes was calculable the way he describes it, and he went after the drivers, there's a good chance he could make a claim for more than the value of those cars. So if all they lost was the cars, on one hand, it might be that they got off cheap. But I'm simply pointing these things out. As a lawyer, you have to understand that not everything I point out is what I think the answer is, nor is it what I think is the correct thing. I'm simply telling you what the law says, what possible outcomes are, okay? So I'm not saying that these guys who are doing this allegedly need to be fined hundreds of thousands of dollars. I'm simply saying that the owner of the lot could make that argument if that kind of damage was done to his lot. So this is just food for thought. But the important thing here is that I believe that the drivers of the vehicles were cited for reckless driving. And because they were reckless driving while stunt driving, such as figure eights, sliding, drifting, and donuts, then they are also a public nuisance. Two different things. One's a driving violation, and one is a city ordinance within the city of Flint. So there you go. That's the answer to the question. And like I said, I did a video about the situation in Flint and the street shutdowns and the drag racing years ago, but I realized that not all of you probably saw that video. So there you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Leto's Law.
Never trust a computer you can't throw out the window.
Nah.
Next one.
Yes, please.
Honda owner
Litigates, goes to court, over unusual tire wear.
Welcome once again to Leto's Law. Here's Steve Leto.
I got this story from a whole bunch of people, including Eric, Ken, and Jeff. And his minivan owner takes Honda to court, claiming vehicle defect causes excessive tire wear. Rick Barrett wrote this. The Milwaukee Journal Sentinel ran it. Stories out of Fond du Lac. One of those nice town names is fun to say. Less than 2 years after he purchased the Honda Odyssey, a consumer says he noticed an issue with the tires he believed was dangerous. The inside shoulder of all four showed excessive wear at 28,000 miles. Now, the man is a mechanical engineer who's kept a handwritten log of nearly everything regarding the minivan he bought new in late 2020. So Honda and the dealership that serviced the vehicle say there's nothing wrong with the vehicle. If there is, it's not something they got to do something about. So he says he wasn't going to keep paying to replace tires that wouldn't last their normal lifespan. He says not willing to give up because as a mechanical engineer with 18 years of experience and a significant amount of automotive background, I knew this was a safety issue. So he filed a complaint with the state and he later sued the manufacturer. Now, the trouble with the tires surfaced in November of 2022. And he said the uneven wear pattern was especially troublesome because it could have gone undetected because it's on the inside. And of course, bad tires here could lead to a loss of traction. So he said a service department manager at the dealership told him they had seen this problem before, including once on a Honda with even less mileage. So he took the vehicle to a tire place who confirmed that for safety reasons, all four tires on his vehicle needed to be replaced. So the tire manufacturer expects a 50,000-mile tire life, or getting less than half of that before crossing the safe tread threshold, he said. Now, he said he's not blaming the manufacturer of the tire because he believes the abnormal wear indicates a problem with the vehicle rather than tire construction. He filed a complaint against Honda with the Wisconsin Department of Agriculture, Trade, and Consumer Protection. His filing included a 40-page presentation outlining the issue and his documentation. He got a letter back saying that Honda had not responded to attempts at mediation. So they say, look, we got it. We contacted Honda. They didn't get back to us. 3 days later, he filed a complaint against the company in small claims court, seeking his anticipated cost for replacing tires over the life of the vehicle and other expenses. A court commissioner heard the matter and awarded him $7,200 plus court fees. So he said, yeah, legal system works. But that hope was soon dashed when Honda successfully appealed the ruling. And small claims court judgments are often
Okay,
rather
that's
easy
the
to
game you're
appeal,
gonna
the same way
play.
they're easy to file.
See you in May.
In a June
Court.
2024 trial in Dane County Circuit Court lasting less than 2 hours, the judgment was thrown out. The Circuit Court gave two reasons for granting the motion to dismiss. First, it says that he failed to bring the issue with the tires to the attention of Honda within the 12-month warranty. However, the man says that his warranty is for 36,000 miles. And he'd also purchased an extended warranty that goes up to 120. But the court also concluded that this was a complicated issue that would require an expert witness to explain the problem and say, yes, in fact, this is a design problem.
Yeah.
Now, the man himself said that he explained to the court why it's a problem and that because he's got a background in mechanical engineering, his opinion should be enough to get past this threshold. He has a bachelor's degree in mechanical engineering from Michigan Technological University in Houghton, Michigan, go Huskies, and a master's degree in engine systems from University of Wisconsin-Madison. Currently, he's an engineer at Mercury Marine, outboard engine manufacturer, based in Wisconsin. So he appealed the circuit court decision. And on May 22nd, the Wisconsin Court of Appeals granted a new trial, saying, among other things, the circuit court erred in disqualifying him from offering testimony about the cause of the tire wear and requiring him to present an expert witness to replace his own ability to testify. The court elicited only fragmentary testimony from him, prevented him from testifying further, and did not purport to make factual or credibility findings. So on July 7th, the complaint found its way back to Dane County Circuit Court. So that's where we are right now. And it's an interesting question because once in a while you'll hear about something where somebody goes, I've got this problem with my vehicle. It's wearing out tires too fast. It's wearing out brakes too fast. It's consuming oil a little bit too much. And all of these things are things that could happen in most cars to some degree. And I've seen it before where somebody goes, I've got a brand new vehicle. And when I bring it back in for an oil change, you go, you're 2 quarts low. So I started checking my oil, and sure enough, halfway through the service period for an oil change, I'm down a quart. Where's it going? Or brake wear. And the weird part about these things is they can almost always point to something else and go, well, the person rides their brakes. This person drives poorly, you know? And if there's a design flaw with a car and there's tens of thousands of them on the road, why don't they all have this exact same problem? Now, you're going to say, but Steve, I heard in the story a moment ago that the dealership said they've seen this before. He said a dealership told me they've seen it once before, making his the second one they've seen. But the dealership has sold more than 2 of these vehicles, and so it makes you wonder. But again, we're not discussing whether or not he's right or wrong. We're arguing about whether or not he should get to a jury. Remember, a trial, full-blown trial, if you choose to get a jury for your trial, is you getting in and getting a day or 2, figuratively speaking, in front of the jury. And the jury decides whether you're right or wrong. And so what the court's getting at with the expert testimony is that when you come into court, you can't just make all kinds of allegations and just say, that's defective, this is defective, this is designed poorly, this caused that. There are things that require someone with expertise to connect up for a jury. Best example I can give you is someone getting medical treatment. Okay? So let's suppose that you got injured. You're suing somebody for your injuries. And part of your medical treatment involved you having all kinds of operations. For you to come into court and say, I was injured, I went to the hospital, got all kinds of operations, give me money, you will lose that case if that's all the evidence you have. Because the other side's going to say, they got injured, but all the stuff that was done to them was unnecessary or unrelated to why we're here. They had pre-existing conditions. They had bad doctors. So you will need to bring in an expert who's going to say something to the effect of that the treatment that they underwent was medically necessary to a degree of certainty that a doctor such as myself, you get a witness as a doctor, having reviewed the records or having done the work myself, it was necessary. And it's one of the things that I think a lot of jurors are surprised by when they get brought in to hear a case, if they've never served on a jury before. All they've seen is what happens on television with lawsuits, is how much of this stuff is put in that's simply there to underscore the validity of the claims. And so in this case, if you said, Steve, back way up and start from square one, and you actually are going to handle this guy's case, and you're going to take it to a jury, what do you need? I immediately need one and possibly two tire experts. I need a tire expert who can look at the tire wear and go, that is a problem. Not caused by the tires, but caused by a design with the vehicle. Then I need somebody, it could be the same guy, but maybe not. Then I need somebody who can say, I believe the problem is this. And then they explain what the problem is. And so I can think of some wacky things that have gone wrong with vehicles. I had a client once, years ago, who bought a brand new Jeep Rainbow. And after a specific number of miles, it was like clockwork, it was either every 2,000 or 3,000, the U-joints would go bad. And it happened more than once. It wasn't bad U-joints. It's a bent drive shaft, or a damaged drive shaft. And the drive shaft had been dinged in such a way that it was no longer balanced properly. It may have been put up on a hoist run. It may have bounced over something, but it happened from day one. My client buys the vehicle, and it starts going through the U-joints, and the dealership never figured that out, believe it or not. And I had an expert look at it, and the guy goes, yeah, it's a damaged drive shaft. All the U-joints are bad. The drive shaft is bad. Replace the drive shaft, and you're good. The problem is they didn't catch it in time to get it outside of the lemon law. But it's not my job to fix the cars. It's my job to figure out what's wrong with them when they qualify with lemon law. Okay? So in a case like that, you have to bring in somebody who'd say, okay, jurors, here's what a drive shaft is, for those who don't know. And here's a nice illustration of one. And here's a photograph of the drive shaft off of the plaintiff's vehicle. And here is the ding in the side of the drive shaft. Let me explain to you what happens as this drive shaft now spins as it goes down the road. And the vibration it sets up in there eventually destroys the U-joint or two. And not plaintiff's fault. It's probably not a design defect, and it's not really a manufacturing defect, but it is damage that was done to this client's vehicle before he took delivery of it. You know, someone's going to say, but Steve, how do we know he didn't damage it? There's no evidence that he did. And by the way, they never raised that argument. So in this guy's case, can he testify to the court and say, I'm a mechanical expert. I have 2 degrees in mechanical engineering, and I've observed this and looked at this and studied this, and I consider it to be a design defect. Here's why. That would be enough to get him to a jury. But I would not recommend that he do that, because obviously he would appear to be a very biased witness because he's got an investment in the case. It's his case. So you go find a professor, someone who teaches this stuff, or you go find somebody who works at a job doing this kind of work, but for a different company. Or believe it or not, there's retired engineers up there who'll testify for you, who'll examine a case, give you an opinion, and testify. You hire one of those experts. It's going to cost you some money. But if you win, you can often get your money back from the other side. So it's an interesting case, but the plaintiff says that he thinks it's a problem that's across the platform, but we only know of the 2 cases, and one of them is really hearsay. So don't know what to say about it, but it's an interesting case in that he handled the case by himself through the appellate process and won. But now he's hired an attorney who's going to let the law firm that he hired take care of it, which I highly recommend. I think he'll get further doing it that way. So Eric, Ken, and Jeff, and everybody else, thank you very much. Rick Barrett wrote that for the Milwaukee Journal Sentinel. Minivan owner takes Honda to court, claiming vehicle defect causes excessive tire wear, and his case is still alive.
Questions or comments below? We'll talk later.
Thank you for watching.
Lato's Law.
Life moves pretty fast. If you don't stop and look around once in a while, you could miss it.
Yeah. Now what? Huh?
The Rain Man will probably have something for Matt.
It's just keto. What's this one?
We listened to that over going to
Thomas?
3-day fast.
In buying
Sorry. Three-day fast in 18 hours, you know?
it binds to a nicotine receptor inside the white adipose tissue, inside our white fat, and it initiates lipolysis. So with this, it seems like this would be a really cool thing to utilize for additional fat loss, particularly when you're fasting. But there's downside.